Supreme Court has struck down Section 21D of the Pakistan Army Act. This section of the Pakistan Army Act gave military courts a jurisdiction to try civilians for certain specific offences, and this section was added in the law during the tenure of Field Marshal Ayub Khan, and 4 judges of the Supreme Court have struck it down as being unconstitutional. In the prevailing circumstances, this is a courageous decision. The offences which fell within the scope of Section 21D were if a civilian attempts to seduce an army officer from their duty or allegiance to the government, or if a civilian commits an offence under the Official Secrets Act in relation to the defence of Pakistan, they could previously have been tried by a military court. In striking this section down, the Supreme Court has essentially held that regardless of the offence, civilians must be tried by civilian courts. This is important not just in the context of 9th May, but overall, the Supreme Court has struck down the only section in our law which gave military courts the jurisdiction to try civilians. And a lot is being said about how this decision is not in accordance with past precedent as set out in the District Bar Association case, and this is not correct. The District Bar Association case was a challenge to a constitutional amendment which extended the jurisdiction of military courts over those individuals who were known or claiming to be part of a terrorist group which misused the name of religion. The challenge was not to the constitutionality of Section 21D of the Pakistan Army Act, and even otherwise, the 21st Amendment had a sunset clause in it which has since lapsed. There are many aspects of the way military courts operate which violate the right to a fair trial and due process. There is no right to a public hearing. Hearings take place in secret without any transparency. Members of the media, the public are not allowed to attend hearings. Serving army officers act as judges. There is no right to a reasoned judgment, and judgments by military courts often simply just say guilty or not guilty without any further reasoning, and there is no meaningful right to appeal. In certain situations, civilians can appeal to a court of appeal comprised of the Chief of Army Staff or one or more officers designated by him. But even in these situations, the appeal that a civilian can exercise lies within the military system itself. In certain situations, civilians can challenge decisions given by military courts in the high courts. However, this challenge is only on very limited grounds. The trial of civilians by military courts also goes against Article 175, subsection 3 of the Constitution, which states that the judiciary shall be separate from the executive, and the military as part of the executive cannot exercise judicial power over civilians, as this creates sort of a parallel judicial system. And the Supreme Court has rightly struck down the section which gave military courts the power to try civilians. And at the time of the 21st Amendment, one of the reasons used to justify the time-bound nature of the amendment was the inadequacy of the criminal justice system. And this is not a sound or a legal basis to hand over civilians to the military, and we must strengthen our civilian institutions, and it is hoped that the decision yesterday strengthens our civilian courts.